So I'm in a galaxy far, far away with, as you can tell, 200,000% humidity, and I'm a bit behind and could not attend the hearing. But I can tell you about the letters regarding the request for admission. Last week, on the 19th, Lively filed a request to the court to deem requests for admissions admitted. So, what are RFAs? What are requests for admissions? Requests for admissions are a discovery device similar to depositions, interrogatories, requests for documents. It's a type of way that you can get information during the discovery process in litigation. And what it is that you make statements, the car was blue. That morning it was raining, and the other side has to either confirm or deny those admissions. So admit that you were wearing a yellow jacket on the day of the incident. Admit that you took 2 steps before you crossed the path. Simple factual admission things in a way to kind of relieve the parties from having to establish certain facts to prove their claims or prove their defenses. So if there's things that we can get past that we wouldn't have to fight about at trial, that's what you would want to have admitted, deemed admitted. Although lawyers will always try to get more admitted, they will always try to get every element of every claim admitted so that they can say, see, the other side admits that all of these things happen, therefore we win. So there are crafty ways to ask questions, and then there's always going to be objections. The other side is always going to object unless they're really cut and dry. The other side's going to object as to part of it, how it's worded, maybe part of it is true, maybe part of it's not true, maybe the way that it's presented is not true. So there's often a back and forth as to requests for admissions, especially if it's asking for legal conclusions. So requests for admissions are typically not limited in number. In federal court, there's a limit as to interrogatories, but there's no real limit to the number of requests for admission, so you can see lots of them. In this case, it looks like there are 500 plus requests for admissions from the Wayfarer parties. 557 to be exact. That is a lot. Even considering that there are numerous defendants, there's only one plaintiff and really only a few claims. It's either hostile work environment based off of gender or retaliation and a couple of other defamation claims. There's really not that many claims and there's really not that many defendants. So it is actually a little bit insane to me that there are over 500 requests for admission. Even if you divide it out, parse it out across all 8 defendants, that's almost 70 requests per defendant. If you recall, there was a hearing earlier in this case about the genuineness of documents. So one use case for request for admissions is to say, admit that this document is authentic, meaning that we will not be fighting about its authenticity at trial. For example, I can authenticate that I sent this particular text message, or this is my handwriting, this is my document that I created. Or you're not sure if that's exactly the one that you had, it's exactly the one you saw, or it's changed in some way, or it's provided by some other source. And so the question of authentication can be resolved through requests for admission so that when we get to trial, we don't have this back and forth about whether or not it's authentic or not. And the judge wanted this because it streamlines things when we get to a trial. If we don't have to fight about the authenticity of documents, then we can just get through the trial and talk about the documents that are there, assuming that everyone can authenticate them. And so it seems like the parties here had sent all of these requests, a number of them, maybe there were even more than 557 RFAs. Maybe the 557 documents and exhibits RFAs were to authenticate all 557 documents and exhibits, which is crazy to me. In any case, it seems like there's some dispute as to whether or not the Wayfarer parties lived up to their side of the bargain in terms of doing it in the time that they had agreed. And so the letters discuss, no, actually, this is what we agreed on, and actually they wanted us to look through all these documents. We couldn't do it within that time frame given how they were provided, how they were questioned or worded. And so the dispute between the parties is whether or not they sufficiently responded to those requests in the time that was agreed between the parties. And Lively is saying, Wayfarer didn't do it properly, so court, you should deem them admitted. Now, it is a possibility to have requests for admissions deemed admitted when the other side fails to respond completely, meaning that you've asked your questions. Was the car blue? Were you wearing a yellow jacket? Was it 3 p.m.? Was it raining the day of the incident? And they just don't respond, meaning they don't object, they don't provide responses within the time frame that they're supposed to. And a lot of time has passed. One of the remedies that you can seek from the court is to have the courts deem all of those requests admitted. It is a pretty serious consequence that only is doled out when necessary, meaning that the party is missing and there's really no other way to get the answer. Not when the other side has provided objections, not when there's meet and confer between the parties, not when there's obviously a desire from the other side to provide a response. And here we're talking about the authentication of documents for the most part. And it seems like Lively is asking that all 8 defendants authenticate every single document. And in order for them to do that, they have to go through every single document with every single defendant. And the time frame that it seems that the Lively side gave to the Wayfarer parties was really, really tight. And so they wouldn't be able to do that. And that's what they say in their response to the letter. I think it's disingenuous, given what we've seen in the exhibits to these letters, that Lively says that the Wayfarer parties had no intention of substantively responding to these requests. That's crazy talk. I mean, there's literally emails that say that they will do that, and it's in the interest of the Wayfarer parties to do so, because they also don't want to be fighting about the authenticity of some of these documents that they themselves may be using at trial. The Wayfarer parties say, in any case, this is an extreme measure that they're requesting. We also have committed to authenticating as many of the documents as we can before trial, and Your Honor, trial is not till March 9th of next year. So there is sufficient time for the parties to collaborate and authenticate the documents at question. Again, the Lively parties are seeking an extreme remedy through the discovery process to club the feet of the Wayfarer parties in being able to defend their claims properly. Another example where potentially client-driven or suggested by the firm to not play nice in this lawsuit. This is not something the parties should be fighting about at this point. This is not something that they should be taking to the court and wasting the court's time with. Because once we get through summary judgment, once we get through MJOP, that's when we really know what the claims are that are going to go to trial. That's when we really are going to know what kind of documents we're going to need for the trial, we being both sides. So to even bring this to the court's attention and have the court address this now is really just a waste of judicial resources, in my opinion. I haven't seen an order on this, and if I missed it, I'm sure you guys will tell me, but I can't imagine that the court is going to deem them admitted. He might hold a conference, and actually there is a conference coming up on the 9th, so I'm sure this issue will come up then to be like, where are we at with authenticating? What's the issue? Let's resolve it. I personally don't think that Lively's team filed this thinking that they would win it. They're just doing anything and everything they can to create work for the other side. That's what this proves to me.